Oyez, oyez! Hi, everybody. Welcome to the McGeorge 52nd Annual Final Four Oral Argument Competition. I am honored to welcome our advocates, their families, and supporters, and to welcome everyone on the YouTube live stream to McGeorge's 52nd Top Oral Advocate Competition. I also want to welcome and thank our distinguished panel of judges who will be hearing tonight's oral arguments. Judge Daniel Calabretta of the United States District Court for the Eastern District of California, Justice Jonathan Renner of the California 3rd District Court of Appeal, and Justice Amy Feinberg of the California 3rd District Court of Appeal. We are very proud of McGeorge's Top Oral Advocate Competition and our Global Lawyering Skills Program, and we're grateful to all of you for supporting our advocates and coming to watch them demonstrate their mad skills. With that, I'll step aside and let Professor Moylan start the show. Good luck, advocates.
Okay. Good. We'll leave that there for all of you. Can you all hear me? A little louder? No one ever says that to me. Okay. Welcome. Thank you for being here. As Dean Prosky said, we are excited about tonight and this oral argument. For those of you who are not familiar with the Global Lawyering Skills Program, this is the culmination of 3 semesters of really hard work by a lot of you. And I will say this semester was particularly hard work, my fault. But the problem was a hard one, and everyone really rose to the occasion. For those of you who did not live through the problem, it involves some really complicated issues of statutory construction, of evidence and evidentiary exclusion, and separation of powers under the California Constitution. This is a moment in time, I think in particular, where it's really important for law students and lawyers to be thinking deeply about the law, about the ways in which the law operates, about the ways in which the law should operate, and about kind of our structural and foundational principles, both in our federal system and in our state system. And so I really wanted this to be a problem where students would have to dig in and think a lot about what are appropriate exercises of power and why do we have lawyers here to ensure that we have safeguards and that we have guardrails against which one branch or the other should not overstep. So this problem brought into focus those concerns. The part that you're not going to hear about tonight was a separate issue where one of the deputy attorney generals breached confidentiality, and so the students also had to grapple with some rules of professional conduct this semester. And it was a challenge, but everyone rose to it, and I feel great about that. So tonight you're going to get to see the results of our competition round. We had 2 students from each of the 10 GLS III sections who advanced to the competition rounds for oral advocacy, and we winnowed it to 8, and then we winnowed it to 4, and the 4 people here tonight for the Appellants Council, Taylor Horton and Hope Austin, are representing the appellant. And for the appellees side, we have Michaela DuPont and Sarah Walling. And these 4 are the last standing and will face the real judges, all of whom have experience in the governor's office and the attorney general's office before they were judges. Ooh, yes, they know all about these cases. It's going to be really fun. So we will also, just to give you a little what the evening holds, we're going to hear from the advocates. Each advocate will have a total of 8 minutes. One of the appellant's advocates will have the ability to reserve time for rebuttal, and so we'll give a few minutes of rebuttal after the appellee's side goes. Then the judges will go to deliberate. When they come back, we will be awarding the Best Brief Awards. You see the list of nominees for the Best Brief in your program. And we will then name the top oral advocate of the evening. After that, there's a reception that everyone is invited to attend, and I'll tell you more about that later. For now, we're going to proceed with the arguments. I'm going to call the case, and then we will get going. So, calling case number 256174, Capital Climate Group versus Governor Fiona Perry. All rise. We will have our distinguished bench come now.
All right, good evening and welcome to the Court of Appeal. You may be seated. All right, we have one case on calendar this evening. This case is Capital Climate Group versus Governor Fiona Perry and the Governor's Office of Land Use and Climate Innovation. If I could have counsel for the appellant stand and state their appearance for the record, please.
Taylor Horton for the appellant, Your Honor.
Thank you.
Hope Austin for the appellant.
Great, thank you. And counsel for the appellees or respondent.
Sarah Walling for the appellees, Your Honor.
Great, thank you.
Michaela DuPont for the appellees, Your Honor.
Thank you. You may be seated. And counsel for the appellant, would you like to reserve time for rebuttal? I understand that there's 16 minutes allocated to each side.
Yes, Your Honor. I'd like to reserve 2 minutes for rebuttal, please.
Okay, very well. All right, with that, appellant, if you would like to approach the podium, you may proceed when you are ready.
Good evening, Your Honors. And may it please the Court, my name is Taylor Horton, and I, alongside my co-counsel, Mrs. Hope Austin, represent the appellant Capital Climate Group. I will be arguing that homelessness is not a valid cause for a state of emergency, and that the trial court erroneously and prejudicially excluded the affidavit of Luke Remus. Mrs. Austin will be arguing that Governor Fiona Perry's executive order violated California's constitutional separation of powers. This is a case about drawing a line between valid emergencies and social policy challenges. This court should reverse the trial court's decision on this issue for 2 reasons. First, homelessness does not qualify as a condition of disaster or extreme peril.
Counsel, let me interrupt you and ask you a question about that. The line that I think you were trying to draw can be a pretty subtle one. And even the statute that is at issue here, and I'm thinking about Government Code Section 8558, has a pretty long and varied list of situations that can qualify as an emergency under the Emergency Services Act. And I'm particularly interested in the legislature's decision to include air pollution. How is homelessness really that different from air pollution? Both strike me as not acute but chronic situations.
Certainly, Your Honor. The enumerated conditions within Section 8558B vary from fires and floods to epidemics, cyber terrorism, and even including air pollution as well. These enumerated conditions suggest a state of emergency is appropriate in 2 scenarios. First would be a naturally occurring disaster, such as something like air pollution, or a sudden acute emergency that requires immediate response for relief.
So how would you distinguish the Schwarzenegger case involving overcrowding at prisons? Which category does that fall into?
The case of California Correctional Peace Officers Association versus Schwarzenegger is distinct for 2 key reasons, Your Honor. First and foremost, there's express statutory authority for the governor's actions to respond to an emergency that threatens the lives of prison inmates. And that's contained within Government Code Section 8658, indicating that a governor does have the power to transfer inmates outside of their facilities when faced with an emergency.
And was that the basis for the governor's declaration of a state of emergency, that statute? It wasn't based on Government Code Section 8558?
They're intrinsically tied, Your Honor. And additionally, California prison overpopulation was subject to very unique constitutional concerns that aren't present here. Governor Schwarzenegger was under a court order to reduce prison overpopulation because of serious Eighth Amendment violation concerns.
So, counsel, you began your remarks by talking about the phrase or the term extreme peril. And Governor Perry's testimony in this case sets forth her judgment that individuals experiencing chronic homelessness do face conditions of extreme peril. Why wouldn't we defer to that judgment?
Certainly, Your Honor. She does indicate on the record, in their state of emergency on the record at page 23, as well as in her deposition testimony at page 19, that there are some serious concerns that homeless individuals face. And cases such as Schwarzenegger have indicated that there should be deference given to the governor. But none of these cases have gone so far as to say that this creates a presumption that is not rebuttable. In fact, in Ghost Golf Inc. v. Newsom, the 5th District indicated that one of the most important safeguards against executive overreach in this kind of scenario is judicial review. If there is such extreme deference given to the governor that judicial review is not appropriate or not given, then this would undermine that very safeguard.
Counsel,
Sorry, go ahead, Justice Member.
is your position that homelessness can never rise to the level of an emergency sufficient to qualify under the statute?
Under the current version of the statute, yes, Your Honor. While it is a serious concern, undoubtedly,
Counsel, actually, a question I was going to ask is there any evidence in the record rebutting the governor's factual findings that there was extreme peril to people experiencing homelessness? Because it makes sense to me as common sense matter, being exposed to the elements on the street, food scarcity, violence, communicable disease. This doesn't seem like a case where it's a stretch to imagine that.
certainly not a stretch to imagine that this is a serious concern and that homeless individuals face real issues, Your Honor, but extreme peril is a term of art within the statute. CISA was designed to address a very particular kind of issue, two particular kinds of issues, as I mentioned previously. Homelessness is not one of them. There are unique qualities to the Schwarzenegger case that make it such that it does not stand for the general proposition that any chronic systemic condition could warrant a state of emergency.
So, counsel, the statute also refers to other conditions. What meaning does your interpretation of the statute give to those words?
Other conditions would be limited by those enumerated before it, Your Honor, such as, for instance, some other conditions that could be valid under the statute would be a volcanic eruption or perhaps a chemical plant explosion that could fit under these enumerated conditions as well.
So, counsel, what in your client's view is it specifically about the homelessness condition in California that makes it categorically inappropriate for a response through the Emergency Services Act?
It is not a naturally occurring condition, Your Honor, and it is not a sudden acute emergency like those listed in the statute.
So there are, of course, conditions listed that are not naturally occurring. Electromagnetic pulse attack might be one of those. Air pollution, I suppose, depending on what the cause is, could potentially be another. So I'm not sure this list is fairly read as requiring that it be something that arises from the natural world. But you would say, and correct me if this is wrong, if it is a man-made situation, it has to be acute?
Not necessarily, Your Honor. A fire, for instance, would be appropriate under this act, whether it was started by a lightning bolt or a match. The effect, or the importance, is that it is generally a natural disaster. Alternatively, there are sudden acute disasters like that of a magnetic pulse attack or cyber terrorist attack that would warrant a state of emergency. With respect to my second point, the affidavit of Luke Remus addresses specifically whether or not homelessness is within the control of individual localities and whether it requires mutual aid for relief. This affidavit on the record at page 39 and 40 in particular demonstrates that the city of Half Moon Bay has been able to address this situation using entirely local funds and local efforts. It has not required the use of state mutual aid or resources to remedy, suggesting that not only is this not a condition of extreme peril.
Counsel, isn't the aspect of Mr. Remus's declaration reporting about other cities, isn't that necessarily hearsay?
No, not necessarily, Your Honor. he is not reporting other individuals' statements on those efforts as not only a city manager for the city of Half Moon Bay, but as a board member for the League of California Cities that has been actively supporting various efforts to resolve this issue, as he indicates in paragraph 11 on the record at page 41. He has direct supervision and oversight of these efforts. It's not necessarily that he's learning this information secondhand.
But how relevant is it that one city, or maybe a handful of cities in California, is able to tackle this problem? Many other cities we know, including Sacramento and San Francisco, it seems like are not.
Your Honor, I see I'm out of time. May I answer your question and conclude? Thank you. While Half Moon Bay may be a smaller city and have certain advantages, it's nevertheless relevant to demonstrate whether this is categorically beyond the control of individual localities. The city of Half Moon Bay and their response offers a blueprint for other cities to follow. And just because other cities have not been able to resolve this situation yet, doesn't mean they cannot. And for these reasons, homelessness is beyond the scope of CISA and is not a valid cause for a state of emergency. Thank you.
Good evening, Your Honors, and may it please the court. My name is Hope Austin, and I represent the appellate Capital Climate Group. I will be addressing how Governor Fiona Perry's executive order unconstitutionally violates the separation of powers. This case is about priorities, promises, and process. Or more specifically, a governor who prioritizes campaign promises over the legislative process. We respectfully request that this court reverse the Sacramento Superior Court's decision for two reasons. First, the executive order overrides action already taken by the legislature. And second, the executive order is an unconstitutional, indefinite expansion of executive authority.
Counsel, can you please address the decisions that have upheld the governor's authority in similar circumstances, or upheld the statute as against the type of constitutional challenge you're asserting today?
Yes, Your Honor. In the COVID-19 cases, such as Newsom versus Superior Court, Ghost Golf Incorporated versus Newsom, or 640 10th versus Newsom, that court found that the executive authority under CISA was proper because the governor respected the legislature in making their action. And specifically in Newsom versus Superior Court, this district found that Gavin Newsom maintained the separation of powers when he issued his executive order permitting full mail-in voting during the COVID-19 pandemic. When the legislature passed an act akin to that order, he withdrew it. That's not what we have here. On June 30th, Gavin Newsom signed two bills into law, AB 130 and SB 131. Those bills suspend CEQA for specific infill housing. Less than 48 hours later, Governor Perry issued her executive order, found on pages 25 through 27 of the record. This order.
One of the safeguards, arguably, in the Emergency Services Act is that it does give the legislature the express power, one of the two enumerated ways, in fact, to terminate a state of emergency. Is that by a concurrent resolution of the legislature, they can override and end the governor's state of emergency. Does that save the act and this particular proclamation from the separation of powers argument you're making?
Not on its face, Your Honor. That takes me to my second point. That safeguard is such that the legislature or through judicial review can run a check on whether the governor has permitted the executive order to extend past when the conditions warrant. Found on the bottom of page 26 of the record, the governor has invoked her executive order for an indefinite period of time, even allowing it after a 5-year grace period to expand to other developments. There is no guidance or direction in this executive order, again found on pages 25 through 27 of the record, that delegate exactly when the conditions warrant.
And if the legislature disagreed with Governor Perry's judgment, doesn't the legislature retain plenary authority to disagree with her and in effect supersede her judgment that there is an emergency?
Yes, Your Honor, the legislature can end the emergency. However, found in Ghost Golf Incorporated versus Newsom, the 5th District found that that safeguard is rendered weak because the governor, nothing prohibits the governor from starting the state of emergency again in that quasi-legislative action again.
Well, that might be, I think that would be a different case, right? I think then you might have a much stronger case if they had ended it, legislature ended it, and the governor restarted it. I want to go back, though, to your first statement that it overrode the will of the legislature.
Yes.
Isn't it true by definition that every time the governor uses this authority, they are overriding the legislator? I mean, that's the whole point of this, is that he gets to waive state law. So in every instance, it's overriding the will of the legislature. So why is that constitutionally significant?
Your Honor, in the other cases, the COVID-19 cases, the med-flight cases, such as Macias versus State of California, and in Schwarzenegger, the law that was amended or suspended had been enacted for years. Here we have 2 bills that have only been in effect for less than 48 hours and have yet to play out to see if they can effectively address this issue. These bills were carefully crafted by the legislature to balance CEQA and building housing for the unhoused. And then the governor stepped in and issued 2 bills her executive order overriding those 2 bills and issuing it to be indefinite. And these can be distinct from the COVID-19 cases. There, Gavin Newsom issued an executive order, and he directed the public health department to determine when public accommodations can open up. The public health department established a metric: positive tests per 100,000 COVID tests administered in each county. Here, we have no such direction for LCI to determine when homelessness would be alleviated such that the executive order is withdrawn.
Was there any such metric in the CDCR case?
In the CDCR case, Your Honor?
Yeah, in the case where this court upheld the governor's state of emergency with prison overcrowding, was there any specific metric contained within the executive order?
There was, Your Honor. The specific metric was inmates per beds and then inmates per square footage of free movement. These metrics are specific such that we know when the executive order ends. Further, in the Schwarzenegger case, the court established a 3-judge panel that is still in effect today to make sure that prison overcrowding has not exceeded to the level of being an 8th Amendment violation. Again, here, found on the bottom of page 26 of the record, we have no direction for LCI to establish a specific guidance for when homelessness would be alleviated, and it overrides action already taken by the legislature on this issue. It's for these reasons we request that you reverse. Thank you.
Thank you. Counsel for the respondent or the appellees?
Good evening, Your Honors, and may it please the Court. My name is Sarah Walling. I and my co-counsel, Michaela DuPont, represent appellees Governor Perry et al. In this matter. I will be addressing the statutory issue, and my co-counsel will be addressing the constitutionality issue. We are requesting that this court affirm the lower court's judgment. Your Honors, this case is about honoring the will of the people to address a humanitarian crisis, homelessness. And we're requesting that this court affirm the lower court's ruling for 2 reasons. First, that homelessness is an extreme peril under CISA due to its magnitude and its impact. And second, that even if the affidavit were meant to be admitted, its exclusion was a harmless error because it didn't prejudice the appellants.
Counsel, could you please address opposing counsel's argument about how homelessness is different in kind from the types of emergencies that are enumerated in the statute, things like floods, storms, epidemics, riots. Homelessness does seem different than those enumerated categories. Can you respond to that argument, please?
Yes, Your Honor. It's our position that homelessness does fall under CISA. Under Statute 8550, in the purpose section, it talks about how CISA is there to protect the health and safety of Californians and people who live in California. Homelessness is similar to prison overcrowding in that it's not enumerated in the statute. Nowhere in the statute does it talk about prison overcrowding. However, because the statute itself is an open list, we're using the statutory construction justum generis to really read into what the legislature intended to do by creating CISA.
So could the governor declare a state of emergency involving poverty?
Potentially, Your Honor.
What about gun violence?
Potentially.
What about inadequate access to health care?
All of these issues, if they meet the 3 requirements under CISA, it could.
So you see where I'm going with this, and I know this
Yeah.
overlaps with the separation of powers argument, but the more broadly you interpret the Emergency Services Act, the more pressure that puts on to the separation of powers argument. And what you're telling me is that basically any social ill that the governor thinks is a problem and could cause extreme peril, which is a lot of them, could be a state of emergency, giving the governor almost plenary power.
Your Honor, we acknowledge that there are safeguards within this mechanism, and my co-counsel will talk more about this during the constitutionality argument. But there are safeguards in place to put a check on this power. However, it's important to note that every single California court that has addressed this issue has sided with the deferential nature of CISA and has sided with the governor's ability to declare an emergency under it. And this case is no different. Whether it was Ghost Golf out of the 5th District, 640 10th out of the 4th, or this court in Gallagher, all 3 decided that COVID fell underneath this, fell underneath CISA.
Counsel, it may be true that the statutory requirements for announcing or creating an emergency condition by the governor, it's fairly open-ended. But the conditions and the statutory requirements for ending a state of emergency are a little bit more precise. And in particular, Government Code Section 8629 requires that the governor, says the governor shall proclaim the termination of a state of emergency at the earliest possible date the conditions warrant. And it strikes me that that statutory mandate is potentially at odds with the way at least I read the governor's proclamation and the statements, the expectation that the CEQA exemption will remain in place for potentially 5 years or longer. So how do you reconcile the timetable that appears to be contemplated by your client with the statute's requirement that the emergency be terminated at the earliest possible date?
Yes, Your Honor, the emergency must be terminated at its early possible date. And looking to Gallagher in this court and looking at how this court determined COVID and the issue and the indefinite issue around COVID, it's very similar with homelessness. Once conditions warrant, whether that is within or beyond this time, the governor may then rescind this state of emergency. Similar to what this court found in Gallagher, which was the COVID pandemic. Even though it was indefinite, we didn't know when it was going to end. And to be frank, people still get sick from COVID today. So it's not necessarily even about solving the problem entirely, but it is about addressing the major issue. In this case,
But at least with COVID, there was, declarations by the World Health Organization and other entities that we were in a pandemic. That declaration was listed. There were objective measures, right? Case numbers coming down. What is the objective measure here? I mean, you just kind of said it could be indefinite.
yes, Your Honor, it could be indefinite in the same way that COVID was indefinite. But there are objective measures in the actual executive order itself that puts limits to this.
So counsel, I think what's troubling me is what appears to be an expectation that it's going to be indefinite. So when I look at the executive order under the section duration and scope, it says this exemption is to last indefinitely, only to be revoked when quarterly reports are satisfactory. So isn't that potentially problematic, the expectation right at the outset that it's going to be an indefinite CEQA exception?
Our position is that no, that it's not a problem because even though it has indefinite language, that's similar to what was held in Gallagher with the indefinite language and the unknowability about COVID is we don't know when the homelessness crisis will be solved. But it was still upheld even then, and that's why it should be upheld even now. In this case, it has ties really strongly to Schwarzenegger, another case that this court decided, where it decided that 166,000 prison inmates, similar to the 200,000 unhoused individuals across the state of California, were living under dangerous living conditions, disease transmission, and increased risks of violence. And that is found here too, which is why it's an extreme peril. Governor Perry, in her deposition, and as stated in her proclamation, declared this as a threat to safety, health, and welfare of Californians. And so this is a massive issue. This is an extreme peril that must be addressed.
Counsel, is it your view that Governor Perry could suspend any law that she perceived as interfering with her ability to solve the problem of homelessness, for example? Could she suspend minimum wage laws or workplace safety rules that, based on an assertion that those impede construction of housing needed to address this crisis?
Under CISA, Your Honor, she might, because there is nowhere in the language itself that says that the governor must make state the necessary finding to which she proclaims will solve this issue. The proclamation is enough in and of itself, and that's stated specifically in 640 10th, and this court stated that in Schwarzenegger, that just by issuing it in her proclamation makes it a state of emergency, it makes it an extreme peril. And so for our position is that this is an extreme peril because of the health and safety risk this poses to unhoused people and to Californians generally. We're talking about women who are escaping violence from partners. We're talking about kids escaping drug abuse, our veterans that we have left behind and long forgotten. And so this court, this is why I see my time has concluded, if I may briefly conclude. This is why homelessness is an extreme peril to the health and safety of Californians. Thank you.
Thank you.
Good evening, Your Honors, and may it please the court. My name is Michaela DuPont, and I also represent appellees Governor Fiona Perry in her official capacity and the Governor's Office of Land Use and Climate Innovation in this matter. The duty of gubernatorial leadership embodies a command to take action. The governor has a responsibility to look at both people and policy. For that reason, we ask the court today to affirm the trial court's decision on the separation of powers issue for two primary reasons. First, the inherent function of the legislature to terminate the emergency at any time is preserved and respected, which ensures the separation of powers and that balance is maintained. Second, the constitutionality is further preserved by the requirement within the Emergency Services Act for the governor to terminate the emergency as soon as conditions allow. And the governor's executive order does appropriately reflect this duty of revocation. Can
the legislature waive separation of powers issues?
The legislature has a duty to ensure that they can, in their acts, they are able to confer power to other agencies. I would not contend that they can outright waive it because we have seen in our precedents that there is a requirement for that to still be respected. The legislature—
Isn't that basically what your argument is? Because the legislature said we can stop this at any time, therefore there is not a violation of separation of powers. That feels to me like you're saying they've waived it and they can just take it back at any time.
The legislature has not waived it. While it is true, Your Honor, that the legislature is able to reverse or to take back that power at any time or to speak on this issue further, they haven't waived it. In fact, I would contend the exact opposite. They've actually given the governor this authority to be able to step in and act in situations when the legislature may not be able to respond timely or efficiently to the needs that have presented great peril to our community.
Which is certainly not true here, right? I mean, they are actively responding to homelessness, right?
I'm sorry, Your Honor, do you mean the legislature?
Yeah.
So in this case, Your Honor, the primary thing that I would draw the court's attention to is that the legislature, while they have recently spoken, that does not necessarily mean that the state of emergency does not persist. And so what I mean by that is the legislature has recently taken action on this as far as the Assembly and the Senate. However, we've seen in some of our prior cases, such as LaCour versus Marshalls LLC, that in this situation, even when the legislature has spoken recently or has started to take action, that has not undermined a state of emergency.
So one of the principal safeguards one of the principal ways that that courts have maintained separation of powers is a requirement that the legislature define carefully enough what the governor's power is. And I heard your co-counsel articulate a fairly broad reading of the statute that expands to any number of social problems. How has the legislature adequately defined and guided the executive if the interpretation of the statute that you're setting forth is as capacious as I'm hearing?
Yes, Your Honor. So as we saw in the case of Newsom versus Superior Court, what we can look at in response to that question is the purpose of the statute, or the purpose of the Emergency Services Act. And the fundamental purpose of that act was to ensure that the governor had sufficient latitude to appropriately respond to situations of urgent need and emergency, and be able to do that and provide the relief needed. And so I bring that up because in the case of Newsom, it was determined by that court that if the statute itself did provide the guidance that was needed, which was for the governor to be able to coordinate resources and respond appropriately to the conditions as they persist.
So, counsel, it strikes me that that argument makes perfect sense for many of the types of emergency that are enumerated in the statute. Certainly earthquakes, volcanic predictions, sudden and severe energy shortages. There's a number of these conditions that the legislature envisioned that are clearly by their terms going to be something that happens very quickly and without warning, and there's going to be a real need for an exigent response, such that imposing very specific and detailed findings and rules on the executive would undermine the executive's ability to act. This doesn't feel like that type of emergency. So is it appropriate to look for more guidance here than we might with an emergency that was more of an unforeseen immediate event?
Yes, Your Honor. So in response to that, I would also call attention to the Schwarzenegger case. So in that specific case, we had a chronic, arguably public social policy issue that had been progressing for quite some time. And so even though that was not a sudden perilous situation, it still fit our criteria as governed by statute and upheld by case law that it was of sufficient magnitude and it was beyond the control of localities to sufficiently deem it a state of emergency. So even though this issue may not have the same emergent nature as a sudden tornado or another natural disaster might have, the fact that it has been chronic or persistent does not undermine the fact that it still has embodied the primary role of the Emergency Services Act, which is to be able to respond when people are in perilous circumstances.
You heard me ask Ms. Welling about, poverty, medical care. Why couldn't the governor issue an executive order saying inadequate access to health care, or, people are losing subsidies under the ACA, governor creates universal health care? Could you do that, or she do that?
Yes, Your Honor. So in that specific situation, I do believe we need to draw some distinctions because I certainly do not contend that the Emergency Services Act gives unilateral, unrestricted power to the governor. It is to respond in these very specific situations that do meet our criteria. In the situations that you have brought up currently and also that you brought up to my co-counsel, Your Honor, I do think that we have a distinction because some of those issues do also call into direct social policy needs. So direct matters of social or behavioral response.
And homelessness doesn't?
In this regard, Your Honor, we have something that is not a direct result of human behavioral situations. We're not asking the governor to directly step in and provide a response to something that is a direct individual or social choice, as some of the other examples you gave my co-counsel had suggested. This is a systematic issue that has resulted in a complete unattainability and unaffordability of basic housing needs, and it has been perpetuated in response by these specific statutes at issue here that have stymied the ability to construct the housing that's needed. So I would draw distinctions in that between pure social issues and these types of issues that have still, while may have social elements, have not been perpetuated by a strictly social stance.
Where do I find that in the statute?
So this situation, Your Honor, I would call attention to specifically I apologize, with the intent of the Emergency Services Act. So the intent of the Emergency Services Act, going back to that primary purpose, is to respond in situations when we have great peril and it's beyond the needs of the individuals. And so whether it is a social construction or a policy construction, we have to go back to those three primary criteria. And I see my time is up. Thank you.
Counsel for Appellant, you have, I believe, 2 minutes.
Yes, Your Honor.
Great.
Your Honors, I have 2 points on rebuttal. First, the situation regarding COVID is distinct from the circumstance that we have here, homelessness. And second, as Your Honors correctly pointed out, this action, this executive order, does not directly remedy the condition of homelessness. Turning to my first point, COVID is distinct from this situation because it is specifically enumerated in the statute at 8558B as an epidemic. Further, the executive orders in the COVID cases were not indefinite. They had specific end dates, and they had the potential to expand if the metric had not been satisfied, that positive tests per 100,000 tests administered. That is distinct from here, found at the bottom of page 26 of the record, where there is no direction to LCI or any other state agency to define what satisfactory means or inadequate levels of homelessness.
Couldn't someone sue Governor Perry and allege that the statutory condition for termination of the emergency were warranted? And wouldn't that be a check on the governor's power?
Your Honor, it could be, but because of the vague language in the executive order, on its face it is unconstitutional. It has no direct check for a court to be able to determine whether the conditions had ended. Which brings me to my second point.
I'm sorry, I want to make sure I understand that, because the statute requires the emergency to terminate at the earliest possible date if
Yes, Your Honor.
conditions warrant. Isn't that the ordinary thing a court would do, is adjudicate the facts on the ground and whether the statutory condition for required termination were satisfied?
Your Honor, in all of the cases in which the governor has invoked CISA, there's been specific guidance as to when that earliest date is. We do not have that guidance here, which makes it unconstitutional on its face. Which brings me to my second point. As this court correctly pointed out, the executive order does not directly
But
address
counsel,
homelessness.
before you proceed, but that's not required by the statute, is it, that the governor in the emergency proclamation or a subsequent executive order indicate exactly by what specific metric it will be determined that the conditions warrant terminating the emergency?
Your Honor, I'm seeing I'm out of time. May I briefly respond and conclude?
You may.
Your Honor, the statute requires that the governor end the state of emergency as soon as conditions warrant. A further safeguard established by this court in Newsom versus Superior Court is judicial review. That is made attenuated when there is no specific guidance as to when this situation, such as homelessness, will end. So, Your Honor, because the executive order has no specific metric and is distinct from the COVID cases, and because it does not directly mitigate homelessness by simply suspending CEQA environmental review, we ask that you reverse. Thank you.
Thank you, counsel. Thank you both sides for your excellent arguments. This matter is deemed submitted. The court is going to be in a brief recess until the next matter is called.
Recess and movement stretch until we come back for the awards part of the ceremony. Good job. Good job. Good job. Good job. Good job. Good job.
Yeah. Because this is what I did for the international thing. I stood here, and they got it. So pretty much same thing. Yeah.
Okay, we are coming back together, and now, first of all, let's once again give a big hand to our advocates. And let's give a big hand for our judges. This was a really good argument, and I know the judges are going to say this too, but you made it very hard for the judges to decide. So, before we get to announcing the top oral advocate for 2025, we are going to announce the winners of the Best Brief Awards. And so, as I mentioned, on page 2 of the program, there is a list of the top 10 appellants brief and the top 10 appellees briefs, one from each of the 10 GLS III sections. And all of these students who you see listed here wrote excellent briefs, okay? They wrote A-level briefs in their section, and the judges behind me, I'm sure, will agree, and they'll probably start nodding when I say this, that oral advocacy is great. An oral argument can sometimes change the mind of a judge, but the brief, the written product, the work that goes into that, the brief is the thing that the judges have before the argument, and it's the thing that the judges have after the argument when they're writing their opinions. And it is just critical to be a good writer. To be a good lawyer is to know how to write and frame your arguments and to be able to persuade with your written word. It is such a critical skill. So the students who did amazingly well on their brief should feel incredibly proud tonight. And I'm going to announce the top 4 as selected by the Best Brief Committee. But every one of these briefs was outstanding work. And so let's give a hand to all the nominees. The Best Brief winners should please come down as I read your names for the top 2 on the appellant side. The first one is Angus Nelson. Come on down, Angus. Here's your
Thank you.
Yay. Congratulations.
Thank you. I appreciate it.
Okay, yeah, we'll swap. And then you can stand with the judges and take one too. Okay, go back. Stand with them.
Thanks, guys. Nice to meet you.
Good to meet you.
Congratulations.
Thank you. I appreciate
Hey, congratulations.
it. Which side? Sorry.
Oh, that's perfect, yeah.
I seem to be missing a certificate here. I'm missing one certificate. Is there one up there? Well, I happen to know that the second one, which I don't seem to have a certificate for, but I will promise to get, oh, I have a certificate. Thank you. Whew. Oh, phew. Okay. The second appellant's brief is Karina Cardenas. Oh, you want a picture with the judges? Go ahead.
Congratulations.
Away, I promise. Okay.
Congratulations.
While she's getting her picture taken, we're going to have the 2 appellees come down. You can both kind of come at the same time. The first one is Jenna Masali. And the I am shocked I picked you. No, I'm so. Okay. Oh, here's your certificate. Here it is. Okay. Oh, scooch this way. Okay. There you go. Okay. I didn't even know.
Congratulations.
Okay, and the
Congratulations.
second one is Annalise Machado. Yeah, no, you're fine. Take your time.
Congratulations.
Okay, and now I'm going to get out of the way. You all are getting a certificate that says that you are in the final four. So I'm going to give these to you now, and then whoever is the top oral advocate will get a separate certificate at a time to be determined. Taylor Horton. Sarah Wallen. Okay, they're taking their picture, and then the judges have to talk. So take a picture.
I think I shuffle a little bit that way. I'll have you stand there. Okay, perfect. 1, 2, 3. Awesome. Thank you.
Okay, good job, everybody. Over to all of you to give some quick remarks and then tell us who the top oral advocate of the night is.
Okay. I can say without hesitation that this is not an easy fact pattern to have to work up. This is not a simple statutory scheme. There's a lot of ambiguity, there's a lot of unanswered questions, and so I consider it to be a very difficult fact pattern. And all four of you did a really excellent job and made our decision very challenging. So.
I would just say each of you did an excellent job. You answered our questions. No one was rattled by the difficult questions. You made eye contact with the bench, and you all really showed how sharp your oral advocacy skills. So congratulations to each of you.
And I'll add, I could tell some of you were a little nervous, and that's to be expected. But none of you let it affect your presentation. You were all very clear, articulate. You kind of got back to your points. And I threw some pretty hard questions, especially at the appellees, and you answered them. You didn't do the, well, that's not this case, Judge, which I very much appreciate. So well done, all of you.
Okay.
All
You
right.
may announce.
All right. It was a very close decision. All four of you should be very proud of how you did. But we have selected Ms. Horton.
Okay, let's get a picture of Taylor, and then maybe we'll have the judges come down and do a picture with Taylor and then with all four of the top advocates. Okay, maybe you come down and we'll do a bunch. Yeah, there you go. Okay, while they're coming down, I will say that after we do the pictures, the reception is in Northwest Hall on the second floor in the little foyer there. So please join us after photos in Northwest Hall. Some of you can go over there now and get to the food if you want. No one's guarding it as far as I know. You're folding it?
I did.
Also did a great job. Seriously, we were away for a while for a reason.
Congratulations. You all did really very well.
Oh, it's on the side? There you go. Sarah, scooch in.
Yeah, you guys they all folded there, so you want to fold yours too. Just so it matches.
Oh, y'all look so nice.
I think we got it.
Great job.
Congratulations. You all did
Proud of you. I'm so proud of you. Does anyone else want a picture with the judges? All right.
I'll be in a second so you guys can do video.
Really good.